Welcome back, dear students. Welcome back to Bajirao IAS Academy. So, we all knew that the prelims examination 2024 is approaching, and keeping the prelims examination in mind, so we have started the current affairs sessions. And in this particular sessions, we'll be discussing most important and most relevant current affairs for the prelims examination perspective. So we'll try to cover all important current affairs through these sessions, and it covers polity, economy, geography, environment, science and technology. So it covers all different subjects, and we'll mostly take up the relevant and important current affairs in the last 1 year, so that you will be able to attempt the current affairs questions with much more confidence. The overall objective of this particular program is to equip you with enough knowledge to attempt any current affairs question, or providing you the basic knowledge about what has been happening in the past 1 year and how UPSC may ask questions from those current affairs. And today we will start with polity current affairs. So we have a few important topics to discuss in polity. And first one that we should discuss is about Article 370 of the Indian Constitution. So we all knew about this Article 370. So this is related to the state of Jammu and Kashmir. And we also knew that this particular article provides special status to Jammu and Kashmir. And if you follow the news that the central government in the year 2019 abrogated Article 370, which provides special status to Jammu and Kashmir. Now, if you can look into the details of Article 370, what was the purpose of including Article 370 in the Indian Constitution? Right? So we all knew the background that when the British left India, Jammu and Kashmir was a princely state, and the British government left the decision of the princely states to either decide the Pakistan or decide India. So Raja Hari Singh of Jammu and Kashmir signed a treaty of accession to India with India, and accordingly India had provided Article 370 in the Indian Constitution to extend a special status to Jammu and Kashmir. So therefore, according to Article 370, it grants special status, and the special status include the Jammu and Kashmir can have its own constitution, can have a separate flag, and they also have the administrative autonomy. However, if you look at other states, they cannot have their own constitution, they cannot have their own flag, and they also don't have the autonomy. But Article 370 provides for a special autonomy for the state of Jammu and Kashmir. And in fact, the Article 370 also restricts Parliament's legislative power. If Parliament passes a legislation on a subject in the Union list, it would be applicable across the territory of India. Even if Parliament passes any legislation on a subject in the concurrent list, then the law of the Parliament will also be applicable throughout the territory of India. But except Jammu and Kashmir, because Article 370 gives a special status, and according to Article 370, if Parliament passes any legislation, then the parliamentary legislation would not be applicable to the state of Jammu and Kashmir unless it is approved by the state legislature. However, there are certain exceptions also. The exceptions are if Parliament passes any legislation on matters including for defense, foreign affairs, finance and communication, so these subjects must be applicable for the state of Jammu and Kashmir. However, with respect to the other subjects, the approval of the State Legislative Assembly of Jammu and Kashmir is must. However, we must understand whether Article 370 is temporary or a permanent provision. And in fact, there was a lot of debate with respect to Article 370 and its status. And in fact, Article 370 is very often known as a temporary or transitional or special provision, and it is mentioned in Part 21 of the Indian Constitution. Right? So Article 370 is very often known as temporary, transitional, and special provision, which is mentioned in Part 21 of the Indian Constitution. So, however, the Supreme Court has intervened to decide whether Article 370 is temporary or permanent. Supreme Court in 2018, in a particular case called Sampath Prakash versus State of Jammu and Kashmir case 1969. So in this particular case, the Supreme Court was held that Article 370 is a permanent provision, right? So it is not a temporary provision, rather Article 370 is the permanent provision. And in fact, the Supreme Court reaffirmed its stand of Sampath Prakash versus State of Jammu and Kashmir. So please remember this particular judgment of the Supreme Court. So apart from that, recently the central government has abrogated Article 370 of the Constitution. So there were multiple reasons for the abrogation of Article 370. So what are those reasons? So one is cross-border terrorism, radicalization of youth, and lack of adequate development in the state, and several other security reasons. So all these factors have been the key factors in abrogation of Article 370. And at the same time, India as a nation, it is the responsibility of the union government to protect sovereignty and the territorial integrity of the nation, as it is mentioned in the preamble. And at the same time, the sovereignty and territorial integrity are also part of the basic structure of the Indian Constitution. So therefore, it is very important to protect sovereignty and territorial integrity in the state of Jammu and Kashmir. And at the same time, the nexus between Pakistan and China and the aggressive nature of China in the line of actual control also poses a series of challenges for India, and all these factors are driving factors for India to abrogate Article 370 of the Jammu and Kashmir. Now, what changes would be made, or what are the changes they came into force after the abrogation of Article 370? That is very, very important. We must understand this. Now, please understand, after abrogation of Article 370, Jammu and Kashmir would no longer maintain its distinct constitution, a flag, or anthem. Now, they will not have a distinct constitution, flag, or anthem, and Jammu and Kashmir would be like any other state in India. And in fact, the citizens of Jammu and Kashmir, or the residents of Jammu and Kashmir, will not possess the dual citizenship. So unlike US, in India, we do not see the dual citizenship of the state and citizenship of the union. Rather, we have a single citizenship, and that is a unitary feature of the Indian Constitution. But with respect to Jammu and Kashmir, it is different. So earlier, when Article 370 was in force, so there was a dual citizenship, but after abrogation of Article 370, there will be no dual citizenship. And apart from that, the newly formed Union Territory of Jammu and Kashmir will be governed as per the Indian Constitution, because understand that after the abrogation of Article 370, there will be no separate constitution for the Jammu and Kashmir. Hence, Jammu and Kashmir would be governed under Indian Constitution. And at the same time, all the residents and all the citizens of Jammu and Kashmir would enjoy the fundamental rights which are guaranteed by the Indian Constitution in Part 3 of the Constitution. And apart from that, Article 360 would also empowers the president to declare the financial emergency, and now this financial emergency can also be declared in the state of Jammu and Kashmir, or it would be also applicable for the state of Jammu and Kashmir, but earlier it was not the case. And apart from that, all laws that are being enacted by the parliament including Right to Information Act, Right to Education Act. So they will be applicable for the state of Jammu and Kashmir. So earlier, Right to Information Act and Right to Education Act were not applicable for the state of Jammu and Kashmir unless they are approved by the state legislative assembly. Now, please also understand before when there was Article 370 was in place. So if a woman of Jammu and Kashmir marries a non-resident, a person who is a non-resident of Jammu and Kashmir, then there is no doubt that a woman inherits the property, but the children of woman do not inherit the property. But now with the abrogation of Article 370, what happens? So if a woman from Jammu and Kashmir marries a temporary resident of Jammu and Kashmir, she would get the right to property. So that is in line with women inheriting the property of their ancestors or their parents. And in fact, now citizen of this country, citizen of India, or of any person outside the state of Jammu and Kashmir, now they can settle in Jammu and Kashmir, and at the same time they can also do a job in Jammu and Kashmir. Okay, so that is also in line with Article 19 of the Indian Constitution. And in fact, with the abrogation of Article 370 of the Indian Constitution, the conducting panchayat elections. Okay, so Panchayat Raj system or Panchayat Raj institutions are being established, and this is a three-tier system of grassroots democracy. And now this three-tier system of grassroots democracy has been established in the state of Jammu and Kashmir after the abrogation of Article 370, and these are some changes that are brought into effect after the abrogation of Article 370. Now recently a petition was filed in the Supreme Court. So the petition has been claiming that abrogation of Article 370 is unconstitutional. However, the Supreme Court has constituted a 5-judge constitution bench to decide on this petition. And this 5-judge constitution bench was headed by Chief Justice of India, and they have upheld the abrogation of Article 370 of the Indian Constitution. So please also remember, the abrogation of Article 370 was done through a presidential order in the year 2019, and it led to the reorganization of the state of Jammu and Kashmir into 2 union territories. So one is Union Territory of Ladakh and the Union Territory of Jammu and Kashmir. And now the state of Jammu and Kashmir stripped off its special privileges. The state of Jammu and Kashmir will no longer enjoy the special status. So next important issue is Uniform Civil Code. So Uniform Civil Code is also regularly in news. So a Uniform Civil Code is actually provided under Article 44 of the Indian Constitution. It is mentioned in the Directive Principles of State Policy. Now Uniform Civil Code actually makes sure that in India that every citizen must be governed by a common law. A common law must govern the personal matters, the religious matters, social matters of different individuals who are belonging to different religions and castes. Now, if you look at Muslims, so Muslims are governed by separate laws and Hindus separate laws. So therefore, Article 44 of the Indian Constitution has provided for the Uniform Civil Code, that is having a common law for all the citizens of this country. Now in this context, the second is 22nd Law Commission of India. So also understand the Law Commission is neither a constitutional body nor a statutory body. So 22nd Law Commission of India sought views of religious organizations and the public on the issue of Uniform Civil Code, on the implementation of Uniform Civil Code, because stakeholder consultation is very important before implementing the Uniform Civil Code. And in fact, the government wanted to implement the Uniform Civil Code, and the Supreme Court on several occasions asked for the central government and respective state governments to implement the Uniform Civil Code. However, so if you look at the states which have implemented the Uniform Civil Code, Goa is the only state in India where all religions have one single common law regarding the marriages of a people, divorces, adoptions, and different other matters. However, recently we have also seen that Uttarakhand has also passed one such uniform civil code legislation. Okay, so please understand, Goa is the only state where all religions have a common law regarding marriage, divorce, and adoption. So, in fact, Article 44 of the Directive Principles of State Policy of the Constitution actually lay down that state shall endeavor to secure a uniform civil code for citizens throughout the territory of India. And please also understand that these principles which are mentioned in the directive principles of state policy are not mandatory, and they are also non-justiciable in nature, but they are fundamental in the governance of the country. And at the same time, these policies must be implemented by the respective governments. So therefore, Article 44 provides for the implementation and enforcement of the enforcement of the Uniform Civil Code. And in fact, the directive principles of state policy are not enforceable by the court. So what does this mean? So it actually means that, imagine that a state is not implementing any provision in the directive principles of state policy. No citizen can go to the Supreme Court or High Court to implement these directive principles of state policy. And at the same time, it is not mandatory on the part of the state to implement these directive principles of state policy. So even though they are fundamental in the governance of the country. Okay, so these directive principles of state policy are actually aspirations that the state must implement. So why they are non-justiciable in nature? Keeping in mind the constraints, the economic constraints, political constraints, and social constraints on the state, or the capacity of the state should also taken into consideration. Okay, so they are not enforceable by the courts, but are supposed to inform and guide the governance of this country. So next article is with respect to the process of renaming a state. So recently, if you look at a few states like West Bengal and Kerala, they wanted to change their names. For example, Kerala wanted to change its name from existing Kerala to Kerala, and at the same time, West Bengal also wanted to change its name from West Bengal to Bangla. Okay, so this is how the states wanted to change their names. And but what is the process to change name of the state? Okay, so there is a certain process and procedure that is being involved in renaming any state, and there is a probability that you may get questions on this as well, because it involves a substantial constitutional principles. Okay, so the Constitution of India actually gives the power to the parliament with respect to creation of new state, altering the boundaries of the state, and changing the names of the existing state. So all the powers are given to the parliament by the Indian Constitution under Article 3 of the Constitution. Okay, so in fact, Article 3 of the Constitution explicitly mentioned the procedure to alter the area, boundaries, names, and even the formation of new state. So all these things are governed by Article 3 of the Indian Constitution. So that essentially deals with the changing or altering the area, boundaries, names, and even the formation of the state. Now, what is the proposal to rename the state? So what exactly, how the proposal is being initiated to rename the state? So first and foremost, it can be initiated either by the state government or by the parliament. Both parliament and state governments have the power to initiate the renaming of state. However, in order to initiate the proposal in the parliament, the prior permission of the president is required. So please also understand, the power to initiate the renaming of the state can be done by either state government or the parliament. However, so if the proposal is initiated in the parliament, the prior recommendation or prior permission of the president is required. However, if state legislature sends a proposal in the form of a a resolution to the central government. So resolution in the sense that the state legislature would pass a resolution in the assembly and then send the resolution to the central government to rename the state. Okay, so after that, this proposal would reach the Ministry of Home Affairs. Okay, so if the state government sends such a proposal for changing the name to the name, and that proposal would be sent to the center, especially the Ministry of Home Affairs. And then this proposal would be taken over by the Ministry of Home Affairs, and then it will give its consent. But before giving a consent to the proposal sent by the state government, it must have, or it must receive, the no objection certificate from different departments and different ministries. For example, Ministry of Railways must provide a no objection certificate for changing or renaming the state, and Intelligence Bureau, Department of Posts, Survey of India, and Registrar General of India, all those departments must provide the no objection certificate to the Ministry of Home Affairs before renaming the state. And apart from that, once the state receives a green nod, or once the state receives a go ahead from the Ministry of Home Affairs, the resolution is then presented in the parliament in the form of a bill. Okay, so this would be the final step in renaming the state. Okay, so once the Ministry of Home Affairs gives a go ahead to the renaming the bill, or renaming the proposal, then the resolution is then introduced or presented in the parliament in the form of a bill. So what will be the procedure in the parliament to rename a state? So it also follows a certain procedure. So the procedure include, first, the bill would be referred by the president to the respective state legislature. For example, Kerala wanted to change or rename the state, right? So now president refer this particular bill to the Kerala State Legislative Assembly to take a suggestions or views of the Kerala State Legislative Assembly. Okay, so it is being referred by the president to the state legislature which are being affected by the bill for expressing their views on the bill within a specified period of time. And in fact, the procedure of sending the bill to the state legislature was actually not part of the original constitution. It was nowhere mentioned in the original constitution, the president referring the bill to the state legislature, but it was only added through the Fifth Amendment Act in 1955. Okay, so after 1955, the Fifth Amendment Act, so it was added in the constitution, but it was not mentioned in the original constitution. So now the views of the state legislature are not enforceable against the president or the parliament. Okay, so when the bill is referred to the state legislature, the concerned state legislature, the views of the state legislature would not be taken into consideration. Okay, so there is no such guarantee that the views of the state governments would be taken care of either by president or the union parliament. Okay, so this is just a conventional customary practice where president refers that bill to the state legislative assembly to take the views of the assembly. And in fact, the parliament also has the powers to dismiss the suggestions which are being provided by the state legislature if it wants. Okay, so either it can accept those suggestions, debate on those suggestions, and at the same time it can also dismiss those suggestions which are being given by the state legislature if it wishes. So after receiving all these suggestions of the state legislature within a prescribed period of time, okay, so there is a certain period of time which is also given when a bill is being referred by the president to the respective state legislative assembly. Okay, so after receiving all these suggestions of the state legislature, or at the end of the prescribed time, the bill would return to the parliament where it gets the further deliberated upon. So there will be a lot of debates, discussions takes place over renaming of the state. However, the final step would be the bill, after passed in both the houses of the parliament, will be sent to the presidential assent. So once the president gives his or her assent to the bill will become an act, and the name of the state stands changed thereafter. So this is actually the procedure which is being involved in changing the names of the state. So the next article, important article, is about the right to silence. See, right to silence is also very often in news. And especially when we talk about right to silence, the right against self-incrimination is, very often linked with the right to silence. Now, what is the context of this particular issue? So, why right to silence is regularly in news? Why? Because recently Supreme Court has ruled that all accused, all people who are accused of any crime, so they have the right to silence, and investigators cannot force them to speak up or admit guilt. So please understand, UPSC now asking these type of questions, so therefore you should have a deeper knowledge about all those things. Okay, for example, the law enforcement agencies have arrested a person, but it is not proved, but they have arrested the accused person. In the custody, the law enforcement agencies cannot force the accused individual to give evidence against himself or herself, and he can remain silent, and that is the right to silence, which is guaranteed by the Indian Constitution. And in fact, Indian Constitution has guaranteed in Article 20, that is right against self-incrimination. Okay, so therefore the accused person cannot be forced by the law enforcement agencies to provide evidence against himself or herself. So Article 20, Clause 3, especially Part 3 fundamental rights of the Indian Constitution, says that it is clearly saying that no person accused of any offense shall be compelled to be witness against himself. So if it is being violated, this will lead to the custodial violence or custodial torture by the law enforcement agencies, and there will be no protection of the fundamental rights of the people. And in fact, there is also chance that the innocent people would be compelled to accept the crime which they have not committed. So therefore, in order to prevent all these negative consequences, the Indian Constitution has included Article 20, Clause 3 in Part 3 of the fundamental rights. And in fact, the Supreme Court, as a custodian of the Indian Constitution, has been enforcing the right to silence or right against self-incrimination. The right to be presumed innocent until proven guilty, and the right to remain silent in the interrogation while during interrogation are essentially flowing from the constitutionally guaranteed right against self-incrimination. So both these rights, the right to be presumed innocent until proven guilty. See, for example, this person is accused. We don't know whether this accused person committed crime or not. But so long he'll be proven guilty, the accused person should also be treated as an innocent person. Okay, so therefore the right to be presumed innocent until proven guilty and right to remain silent in an interrogation essentially flow from the Article 20, Clause 3 of the fundamental rights, which are mentioned in the Part 3 of the Constitution. So that is right against self-incrimination. And this particular right also ensures that the police cannot coerce, cannot force anyone to confess a crime, to obtain a conviction based on that particular confession. And in this context, the Supreme Court has given a series of judgments. So these judgments are also very, very important. Okay, so first judgment is Nandini Satpathy versus PL Dani case. So in this Nandini Satpathy versus PL Dani case, the Supreme Court has ruled that coercing or forcing any person to answer a question within the limits of police station may violate Article 20, Clause 3 Why? Because it is against the right to self-incrimination. The Supreme Court has clearly said that right to silence is a fundamental right, and which is part of Article 20, Clause 3 of the Indian Constitution. However, the Supreme Court, in another judgment, that is the State of Bombay versus Kattikalu Ogath case. So in this particular case, what the Supreme Court has said? The Supreme Court has said that, for example, a person is being arrested. So this particular person is now accused person. Okay, so this person is accused, but he is not yet proven guilty. So therefore, in the State of Bombay versus Kattikalu Ogath case, the Supreme Court has ruled that obtaining the photographs of the accused and fingerprints, signatures, and even thumb impressions would not violate the right against self-incrimination of the accused. So that essentially means the law enforcement agencies can take the photographs, signatures, fingerprints, and also the thumb impressions of the accused individual, and that is not against Article 20, Clause 3 of the Indian Constitution. So please understand the difference between these two judgments of the Supreme Court. And apart from that, this right to silence is only limited to the criminal cases, and it would not be applicable for the civil cases. Okay, so right to silence is limited only to the criminal cases. This is very important. UPSC may ask this question, and since you may have seen only, and if you have gone through the elimination tricks, you may attempt this statement, you may consider this statement as a wrong statement, but it is not wrong statement, because right to silence is limited only to the criminal cases. And at the same time, it is not available if a person is being interrogated under two special legislations. One is the Customs Act of 1962 and the Foreign Exchange Management Act of 1919. So this is with respect to the right to silence, which is mentioned in the Article 20, Clause 3. So next important news article is with respect to Women Reservation Act, or 106th Constitutional Amendment Act. So this is also one of the very important legislations that India has seen. So this is one of the remarkable legislations, 106th Constitutional Amendment Act. So that has provided 33% of the reservation for the women. The historic Women's Reservation Bill 2023, so it was also known as Nari Shakti Vandana Abhinayam. Okay, so please remember this Nari Shakti Vandana Abhinayam legislation. So this was passed by the Parliament and in a recently concluded special session, and in fact this has also become an act because it has been provided by 106th Constitutional Amendment Act, and the President also given her assent to this Women Reservation Bill. So what are the major provisions of this Women Reservation Act? So it contains a set of provisions, and it has also introduced certain new articles in the Constitution. So this is very important for the examination perspective. So this bill will allow 33% of the seats of the Lok Sabha, State Legislative Assemblies and State Legislative Assembly of National Capital Territory of Delhi would be reserved specially for women. Okay, so this is also very important. Please remember that 33% of the seats in the Lok Sabha, not in the Parliament, 33% of the seats in the Lok Sabha and all legislative assemblies, including the National Capital Territory of Delhi Assembly, would be reserved explicitly for the women. However, this particular 106th Constitutional Amendment Act has introduced the following articles to the Constitution, right? So it has also introduced few articles. So first article is Article 330A. So what does this Article 330A talks about? So Article 330A talks about reservation of seats for women in the Lok Sabha, and 332A talks about reservation of seats for women in the state legislative assemblies. 239AA and clause BA. So this specially talks about reservation of seats for women in the State Legislative Assembly of Delhi. And 334A, so this provides a sunset provision. So that would be gradually. The overall objective of introducing Article 334A is that, so there will be a sunset provision. So after 15 years, the affirmative action which is provided for women for their political empowerment would end or would cease to exist after 15 years. Okay, so these are 4 different articles that are being introduced as part of the 106th Constitutional Amendment Act. So apart from that, the bill also states that its provisions will come into effect only after the delimitation exercise is being carried out after conducting this new census. So once, because of the COVID-19 pandemic, we have not conducted census in 2021. Okay, so it was delayed and it was further postponed. But this particular legislation states that, or this act states that, the woman reservation would be applicable after conducting census. Okay, so and published after commencement of the act. And it also provided for the seat rotation. Rotation of the seats reserved will be done after each delimitation exercise. So now, what are the states which have already provided reservations for women? Not in the State Legislative Assembly, but so they have provided reservation for women in the panchayats. So in the year 2006, Bihar became the first state to provide 50% reservation for women in panchayats or in local bodies. This was the first state, please remember. So Bihar provided 50% reservation for women in the panchayat bodies. However, as of now, more than 20 states having 50% reservation for women at the panchayat level. Now, what is this background of introducing women's reservation bill in the parliament? So this was not the first attempt that we have passed a woman legislation or a woman reservation bill. Earlier also there were attempts by previous governments to introduce the woman reservation bill through 81st Constitution Amendment Bill. So that was 81st Constitution Amendment Bill in the Lok Sabha in 1996. So that was the first attempt to introduce or to implement 33% of the reservation per woman. Okay, so this particular bill, the 81st Constitution Amendment Bill, failed to get approval of the House and it was lapsed with the dissolution of Lok Sabha. Okay, so after the dissolution of the Lok Sabha, so this bill has got dissolved. And again, it was introduced by the Atal Bihari Vajpayee government in the year 1998 again. So after 2 years, the Atal Bihari Vajpayee government has introduced it again. But this was also lapsed as the government fell in 1999. So there was no political stability. So there was no clear majority with the governments, and that is one of the shortcomings. Now, even if the governments have the majority in the Lok Sabha, they don't have the majority in the Rajya Sabha. And because of the differences or different interests of these political parties, the women reservation bill, even though it was introduced earlier, it was not passed. However, so after 1999 attempt, it was reintroduced again by successive governments in 1999, 2000, 2002 and 2003. But the problem is that every time they have introduced this women reservation bill, so same time it failed to get the necessary approval from the parliament and even the presidential assent also. So because of that reason, the women reservation bill has not or never came into force until this 106th Constitutional Amendment Act. So before that, before 106th Constitutional Amendment Act also, so there was a Constitution 108th Amendment Bill 2008. So that was introduced in the Rajya Sabha. Okay, so however, Rajya Sabha had passed this bill, but Lok Sabha didn't take up it for the voting because there was a dissolution of the 15th Lok Sabha, and because of that reason the Lok Sabha didn't take it for the voting, and ultimately so the bill never passed But recently, in the year 2023, the government passed the 106th Constitutional Amendment Act, and that has provided 33% of the reservation for women. Okay, so we'll proceed further. The next important issue is Haryana state government providing 75% of the reservation for the local people in the private jobs. Now, why the state government has decided to reserve jobs for the locals in the private sector? Okay, so it is because the state government's inability to create enough jobs, especially the government jobs, and at the same time it also indicating the regionalism on the part of Haryana, and it is mostly keeping in mind the political interests of the party in power. However, so this particular reservation has been clearly violating Article 19 of the Indian Constitution. So that specially talks about freedom to settle, reside, move to any part of this country. So therefore, the Punjab and Haryana High Court has actually declared the Haryana State Employment of Local Candidates Act 2020. Remember, Haryana state government passed this legislation in the year 2020. So therefore, Punjab and Haryana High Court has actually declared this Haryana State Employment of Local Candidate Act 2020 provided 75% reservation in private jobs to state residents, and the state High Court declared this as, or it quashed the particular legislation. Okay, so it is not valid, or the High Court has declared it is invalid. Now, what are the constitutional provisions which are cited in this particular judgment? The High Court clearly stated that it violated Article 19 Clause 1 and Subclause E, because the Article 19 Clause 1 and Subclause E actually guarantees the right to reside and settle in any part of the Indian territory, and Article 19 Clause 1 Subclause G guarantee the right to practice any profession and any business and any trade. But if state government imposes such a restrictions on the residents from other states, then of course it violates both Article 19 Clause 1 Subclause E and Article 19 Clause 1 Subclause G. And in fact, this High Court has also held that it infringes on Article 19 of the Indian Constitution, that is equality before law, and at the same time Article 15, that is prohibition of discrimination on the grounds of religion, race, caste, sex and place of birth. So therefore, because of that reason, the Haryana State Employment of Local Candidates Act 2020 was quashed by the respective state High Court. Now, the next important issue is with respect to the Citizenship Act 1955, especially Section 6A of the Citizenship Act. So we must understand what exactly is this Section 6A of the Citizenship Act of 1955. So recently, Supreme Court has asked the central government to submit details on the number of immigrants who were conferred Indian citizenship or who were given Indian citizenship through Section 6A of the Citizenship Act of 1955. Okay, so we will understand what exactly is this 6A of the Citizenship Act 1955, because 6A, Section 6A of the Citizenship Amendment Act 1955 actually empowers the central government to provide citizenship to immigrants, especially the Bangladeshi Hindu immigrants in India. Now, what is this article or Section 6A of the Citizenship Act 1971? So this particular section was introduced in the Citizenship Act of 1971 to give effect to the Assam Accord. So what is Assam Accord? We will understand this briefly. Okay, so it is actually the Section 6A of the Citizenship Act of 1971 is a special provision for Assam, and that was included in the Citizenship Act of 1971. So therefore, this Section 6A of the Citizenship Act 1971 one actually classified immigrants from Bangladesh, or it was known as East Pakistan, into Assam into three different categories. So there will be three different categories of immigrants: first category, second category. Okay, so this was one category, second category, and third category. Right. So what was the first category? So those immigrants who entered India before 1st January 1966 were deemed to be the citizens of India. So they will be treated as the citizens of India, those immigrants who entered India before 1st January 1966. So the second category of immigrants were those who entered into India after January 1966 but before 25th March 1971, and they will be considered or categorized as foreigners, and they were required to register themselves for the citizenship. Okay, so they will not be treated as a citizens, but they must register themselves as citizens or citizenship. Okay, but it was given only after 10 years. So such persons will not be given any rights to vote, but they will be given a same benefits or same rights as the citizen of India, but they will not be given the right to vote. And after that, the third category is those who entered India after 25th March 1971 were actually considered as illegal immigrants into India. So this is how Section 6A of the Citizenship Amendment Act 1971, so that is a special provision for Assam, was included. Now in this context, what exactly is this Assam Accord? See, Assam Accord is a memorandum of settlement that was signed in the year 1985. Okay, so because illegal immigrants from the East Pakistan or Bangladesh is a problem into Assam and other northeastern states, because these northeastern states are ethnically so sensitive, and that has been changing the demographic of Assam and other northeastern states. And because of those reasons and because of a continued violence in Assam, this Assam Accord was signed in 1985 between Union government under Rajiv Gandhi and the leaders of Assam movement. So this has actually brought to an end the Assam movement that took place before 1985. Now, what are the key provisions of this Assam Accord? So there are certain key provisions within the Assam Accord. So those include that Indian government agreed to secure the international border of the country against the future infiltration. So how can Indian government secure the international borders? Through erecting the physical barriers. So the government will erect the physical barriers like walls, barbed wire fencing, other obstacles at inappropriate places, and that could prevent the illegal infiltration into the Indian side. And after that, the Indian government will also deploy security forces on land and river routes along the international border of India and Bangladesh. So all these things which are part of the Assam Accord, and that will prevent the illegal infiltration into the ethnically sensitive Assam and other northeastern states. Now, when we talk about the Citizenship Amendment Act, foreign tribunals plays a very important role in deciding who is a citizen and who is a foreigner. So these foreigner tribunals are also regularly in use. So we'll try to understand these foreigner tribunals as well. So these foreigner tribunals are actually the quasi-judicial bodies. Okay, so they are judicial bodies, and they also have the powers of a judicial body. And in fact, what is the role and responsibility of these foreign tribunals? So they determine whether a person is a citizen or a foreigner under the Foreigners Act of 1946. And in fact, the Foreigners Act of 1946 has provided for the establishment of these foreigner tribunals. And they first set up in 1964, but they were unique to Assam alone. They are not present in any other states, but these foreigner tribunals are unique to Assam alone, and they were first constituted in 1964. Now, under the provisions of Foreigners Act of 1946, the Foreigner Tribunals Order 1964 only foreigners tribunals are empowered to declare any person as a foreigner, and they have the only right to declare any person as a foreigner. Now, in fact, there will be National Register of Citizens which identifies who are citizens and who are illegal immigrants. So, any person who is not part of the NRC, he will be treated as a foreigner or illegal immigrant. Now, if any person is excluded from the NRC, then the person have the right to appeal before this foreigner tribunal with appropriate evidence to prove himself that he is a citizen of this country. Okay, so any person who is not listed in the conclusive National Register of Citizens, he actually has the opportunity to present the case before the appellate authority, namely the foreigner tribunals. And even in 2019, the Ministry of Home Affairs has actually amended this Foreigner Tribunals Order 1964, and it also empowered the district magistrates in all states and union territories to set up tribunals. Previously, the center actually had the sole authority to constitute these tribunals. Okay, so earlier only the central government used to constitute these tribunals, but the Ministry of Home Affairs in 2019 amended the Foreigner Tribunals Order 1964 and empowered all district magistrate in all states and union territories to set up these tribunals to decide the claims of the foreigners. So this is all about the foreigner tribunals. And these are a few important articles, a few important issues in polity. They are important and you may get questions from this particular sections of current affairs in polity. Okay, so we'll regularly do this so that you will be equipped with adequate knowledge to deal with these current affairs. And thank you so much. Please subscribe to our YouTube channel and also hit the like button. Thank you.